Welcome to the committee, Representative Hassan.
Thank
Would you like to
Madam
move your
Chair.
bill?
Yes, Madam Chair. I move House File 1972 to be referred to Judiciary.
Too long.
And you also have an author's amendment, I believe, to get the bill before us in,
I should have mentioned it. It's not like these are-
oh, you have a delete all?
Yes.
Would you like to move the DE3?
Yes, I move the D3, Madam Chair.
And do you want to speak broadly to that?
It's an amendment that gets the bill in the shape that the author wanted.
The DE3 is before us. All in favor say aye.
Aye.
Those opposed? That is before us, the DE3.
Madam Chair and members, good morning. Thank you for hearing House File 1972, which pertains to pre-eviction notice to tenants. With housing instability being a challenge for many Minnesotans, we must do absolutely everything possible to remove barriers that prevent folks from having a stable place to call home. Housing instability affects having stable employment, education, health, and all other areas of life. More than 13,000 evictions are filed in Minnesota every year, and mostly impacting communities of color, low-income communities, single mothers, and indigenous communities. It's our responsibility to find answers to combat this issue. What this legislation does is, before bringing an eviction action for a non-payment, this bill would require landlords to provide a written notice to residential tenants specifying the basis for future eviction action. This notice must include a total amount due, a specific accounting of that total, unpaid rent, late fees, and other charges, the name and address of anyone authorized to receive the payment. I used to work for Hennepin County as the social worker, and it takes about 14 days for somebody 21 days for Hennepin County and 14 days for Ramsey County for somebody who's applying for emergency assistance. And we also, Hennepin County, and I think all the counties require to have a letter from your landlord that says you are being affected for you to get to access emergency assistance dollars. So what this bill would do is help tenants as well as landlords to work together if somebody lost their job, if there is some financial difficulties that they can't pay their rent. It would allow them to work with their landlord to get a letter from them that says you will be affected, and use that letter to maybe expedite their case in the county or their other resources, whether they're getting money from family members, other social service entities. This would actually allow both parties to work together to find a solution to a problem. And most evictions, as we know, are filed because of non-payment. More than 90% of them are filed non-payment. I have here with me Larry McDowell, who will also explain the bill to us.
Mr. McDonough, welcome back.
Thank you, Chairperson. So what this bill does is has a 14-day notice requirement for the landlord for non-payment of rent. This is analogous, very similar to the type of notice that a tenant would have to give if the tenant were going to file an action against the landlord, a rent escrow action, to have repairs done or to enforce provisions of the lease. So it's really a mirror image requirement as compared to that. And my experience as a landlord, and when I say as a landlord, I don't want to overblow that, not a landlord with like 1 million properties, essentially renting out single-family dwellings from time to time. In my experience, the giving of a notice that I didn't have to give, but I gave, resolved problems and didn't require me to go to court. In my experience, and there are other types of, certainly some landlords that have used these types of notice requirements, and in my experience, they file less eviction cases because the notice prompts the conversation, resolves the problem. I'm not saying that that's going to happen in all cases, but it's certainly the idea behind this is not to simply extend an eviction process. You know, someone might say, well, this is just going to give the tenant an extra 14 days to not pay the rent. You know, there certainly may be situations like this, but in my experience, when tenants have notices to move out or do something, they do that. Now, there's certainly some that don't, but the number of evictions that you have when a landlord in a month-to-month tenancy gives a 1-month notice and then has to file an eviction after the tenant moves out, the numbers of those evictions are just minuscule. And I think that is because the tenant's gotten that type of notice and has that ability to respond. Now, this is a little bit different. That's a shorter notice, but it's concerning a specific issue, which is non-payment of rent. And in my experience, when this type of notice has been given, it leads to a couple of different results in the majority. And the minority would be the eviction case. And the majority would be the tenant and the landlord have a conversation. The tenant maybe gets some help from emergency assistance or for family or for friends, and they resolve the problem, or they work out a payment plan with the landlord, or they take a hard look at their finances and they realize, you know, this place is not affordable. I'm going to use this time to move out. You might be thinking, well, is the tenant really going to move or not? Well, some might not, but most do when they have notices because they understand that eviction records follow people around. That wasn't the case 35 years ago when I started doing this kind of work, but in an electronic age it is. If you file an eviction case against me today, it's going to be something that the landlord community and the public can find out within just a few days. Now, one critical thing that we have in here is related to emergency assistance. And some landlords have told us, you know, man, I wish things would get faster with emergency assistance. I want to keep renting to this tenant. I know this tenant has an emergency, but emergency assistance isn't going to work fast enough. I can't wait. And so a couple things we have in here is to have this notice meet some of the requirements for emergency assistance so that it will shorten up that process. It will verify the amount of the debt. It will verify that there is indeed a fact, an emergency, and that moves that process faster rather than having the county have to reach out to the landlord and say, okay, can you verify this? Can you tell me that this really is an emergency?
I think we'll get the next testifier up. Well, I think we have three more people. Maybe we'll get to them quickly and.
Good morning, Madam Chair, committee members.
Welcome to the committee. Please identify yourself.
Yes, my name is Akua Ellis, and I'm Senior Vice President of Community Impact at the Greater Twin Cities United Way. I'm here to support or speak in support of House File 1972. You know, at the Greater Twin Cities United Way, our mission is to build pathways toward prosperity and equity for all. And we touch over 500,000 lives a year in that work. We fund over 100 service organizations through grant making across our 3 impact areas, which include household stability, educational success, and economic opportunity. Through our work, we know that a stable home is the foundation that enables Minnesotans to thrive, supporting our vision that homelessness and hunger are rare, brief, and non-recurring. Yet many of our families struggle to access and maintain stable housing, with more than 13,000 evictions filed across the state each year. As a result, our nonprofit partners often find themselves addressing the impacts of these evictions. Following an eviction, many families can spiral into crisis, including unemployment, lower educational achievement for their children, and negative health outcomes. All too often, an eviction can ultimately lead to homelessness. Statewide, 1/3 of adults who are experiencing homelessness or who were experiencing homelessness in 2015 attributed their circumstances to a previous eviction. But many of these evictions are avoidable. In fact, 93% of evictions are due to non-payment of rent, which has been expressed a moment ago, and can be settled successfully out of court if tenants have adequate time to apply for emergency financial assistance. However, in Minnesota, landlords are not required to provide tenants any notice before filing an eviction lawsuit, which is a requirement in all but a handful of states across the union. We can do something about that today. Given that tenants are required to allow landlords 14 days to address issues of habitability, we believe the same level of grace should be extended to tenants. Eviction prevention is homelessness prevention. I want to say that again. Eviction prevention is homelessness prevention, and it's a lot cheaper to prevent homelessness than to respond to it. And it's an important way to strengthen our state. Enacting House File 1972 is one tool that will move our state in the right direction. So I would encourage you and ask that you would consider House File 1972, supporting it, and modernizing Minnesota's eviction process. Thank you so much for your time.
Thank you very much. We have Michelle Duran.
Surprise, I'm not Michelle. My name is Eric Hauge. I'm the Executive Director of Homeline. To save the committee's time, I'll just submit a copy of Michelle's testimony. She signed up last week and had hoped to come here today, but unfortunately, as a result of the eviction that's on her record, she was not able to secure her housing choice over the weekend, and so she's living in a weekly rental right now, very unstable housing situation. And so this bill would have prevented the eviction that was filed against her. And I'll submit, I just have one copy.
And we'll make copies of that for all of the committee members. Thank you very much. And then we have Joe Abram. Welcome. Please identify yourself.
Good morning, Madam Chair, committee members. My name is Joe Abraham. Thank you for the opportunity to speak today on the proposed bill. I own and manage 750 apartments in the metro area, the majority of which are naturally occurring affordable housing. And I'm here today to speak in opposition to the proposal. So first, I'd like to share a little data to put the topic of eviction in perspective and give you a little context. The data originates from Matthew Desmond and the Eviction Lab at Princeton University. It's a widely respected national expert on this topic. The state of Minnesota ranks 46th of 50 states in the rate of evictions. Our eviction rate has consistently been lower and fallen faster and further than the national rate for each of the past 10 years. And there are 5 states that require a 14-day advance notice for non-payment, and each of which they have a higher rate of evictions than the state of Minnesota. Evictions are expensive, they're disruptive, and it's the best interest of all parties if we can avoid them. The overwhelming majority of property owners provide flexibility to comply with payment terms. This includes things like grace periods, very soft reminders, and a genuine interest to do anything reasonable to keep customers in our communities, in our properties. This legislation would limit a property owner's ability to offer informal resolution to residents. So I'd like to provide you a summary of description of how my company handles late payments, and while exact details will differ from owner to owner, this should provide a pretty clear picture of a typical industry practice. At 6 days following a late payment, a friendly reminder is sent. This might say something like, I'm sure it's an oversight on your part, but your rent is 6 days late. The second incident would be 10 to 15 days, typically without a communication from the resident or reply. A second notice would be sent, kind of a little bit more, we sent you a notice on the 6th or the 7th. We're reminding you again, we still haven't heard from you. We've tried to reach you. It's important to know that during this process, we're consistently trying to reach that resident through phone call, text, email, post office, whatever method they've preferred, and any way that we have the ability to get a hold of them. At 21 to 24 days, usually a final notice is sent, and in there we will reference an eviction. I'm in the business to keep customers whenever possible. I'm not interested in emptying my apartments. These are customers, and we're the provider of housing to them. I intend to treat them with respect like any good business operator would. And accelerating an adversarial relationship with my customers is just not good business. More importantly, I value my reputation. I take great pride in providing clean, safe, well-maintained homes to thousands of our state's residents. Thank you for listening. My opportunity to speak today is, of course, a little bit limited, but I'm always willing to engage and answer any questions about our business in an effort to provide a better environment for renters in our community. Thank you.
Thank you, sir. And this will also be referred to Judiciary, Finance, and Civil Law, so there will be another opportunity.
Thank you, Madam Chair.
We have no questions to the bill's author or, Representative Pearson.
Madam Chair, thank you. I was still trying to review some of this, and I apologize. I ended up going back to Rochester tonight for a real estate transaction showing of my own, so I didn't have time to fully vet this morning's bills, and so I'm sorry if I'm a little scattered this morning. The specific statute that we're dealing though with is terminating tenancy at will. Can you give me the distinction between, because some of the testimony again this morning seems to be geared towards residential tenants, and here we're talking tenancy at will. Can you describe to me your maybe a few examples of what tenancy at will incidences would be in the state of Minnesota at this time?
Mr. McDonough?
Representative Pearson, perhaps there's a little confusion because that's the first part of this bill. What this bill really does is it takes one sentence out of that statute and adds some language in another statute. The tenancy at will is essentially like a month-to-month tenancy. And what that has, and what the law about notice there is if we have a month-to-month tenancy and the rent's due on a monthly basis and I want to end that tenancy for any reason or no reason at all, I have to give you a 1-month written notice. Now, if I want to terminate that tenancy based on non-payment of rent, I have to give a 14-day notice. Now, you might be wondering, well, why are we taking a 14-day notice out of one statute and putting it into another statute? What the case law has to say, and I'll do this very briefly because you don't want to talk about case law, but what the case, well, okay. So what the case law says is that with a month-to-month tenancy, the 14-day notice there terminates the tenancy, but it doesn't provide a right of redemption for the tenant. And our plan and our idea behind having a notice provision in this other statute was to not eliminate the right of redemption. So that's why the 14-day notice comes out of one statute and we're putting it into another. Sorry about the confusion, but where things are placed in statutes is important.
Representative.
Well, sir, thank you, Madam Chair. And you've done a great job giving one example of my understanding of what one example of tenancy at will would be. But a tenancy at will could be a much shorter term as well. And this statute really could be something that's applied to a weekly tenancy. And so by changing this in the tenancy at will clause, you really make it difficult for other landlords who do manage their practice in a different way, especially for people who aren't paying rent on a weekly unit to be evicted more swiftly and quickly. And I guess I'm just wanting to make sure that we're not just trying to make the assumption that all tenancy at will is on a monthly basis or a longer term than a month, and there are the shorter term instances that this could impact.
Representative Pearson, to be clear, with a at-will tenancy, you're right. It could even be a day-to-day tenancy or a week-to-week tenancy. Those are quite uncommon outside of the shelter world, but they do exist in very small numbers. This doesn't really impact that because any type of at-will tenancy under 504B135, if you wanted to terminate that tenancy for non-payment of rent, would have to be a 14-day notice, whether it was a week-to-week tenancy or a month-to-month tenancy. So this really doesn't impact that issue. What this really is intended to do is to have less evictions, and evictions should not, in my view, just personally be something that people rush to do, because it has a lot of collateral consequences besides just whether someone is evicted or whether rent is collected. The idea behind this is to really engage a conversation that will lead to less evictions, and we really think this will do this. In my experience in this state, when landlords are giving that type of notice, you have lower levels of evictions. And one other thing in terms of the comment of the other testifier about this being adversarial. There isn't anything in the statute that requires this notice to be adversarial. I mean, it can be, the text of this notice can be written in very friendly terms. It's just saying, but this is the notice. It has to say a few things, but this notice can be drafted in a friendly way as opposed to a nasty way.
Representative Johnson?
Chair Hausman, Representative, on line 2.25, it talks about the notice to be sent by first-class mail. Is that going by the date it was postmarked or the date it was received, the 14-day time period?
Mr. McDonough?
My reading of the, sorry, Representative Thompson, my reading of it would be the day of mailing, not the date of receipt.
Chair Hausman, it's what helps a little bit. I'm just thinking back to an incident I had just a couple months ago. I mailed out a bunch of letters, and I knew the people well. I know their addresses. 33 days later, I got about 14 of them back as undeliverable. Last week, I received one of the same letters returned as undeliverable. Now we're talking months, and you only had 14 days. And you're going to have to prove your 14 days that you mailed it, so you're going to have to do probably have to do a receipt with, certified with return signature receipt to prove that it was actually sent there, because when you do normal paper service, law enforcement has to document that service was made. And now you're extending, basically, for those few individuals that just don't want to pay their rent and they're looking for somewhere else, you are giving them probably a free 2 months of rent before they actually do the eviction. There's a lot of evictions, I've actually had to serve them. And we had more than one that before we finally, law enforcement had to go and physically remove the person, it was over 90 days. You're looking three plus months of somebody not paying rent. And now you're giving them more time. I think most landlords do the right thing, do what needs to be done. They want to keep their units rented. They want to make sure that they're safe. Unfortunately, we have a few, and the way it sounds like, because everything is talking about the metro area, because we don't have these problems in greater Minnesota that I'm aware of. We're always talking about the metro, Minneapolis, St. Paul, where these problems are occurring. I guess I'd like to know why we're having those problems in the metro area. You don't need to respond to that.
Representative Howard has a question.
Thank you, Madam Chair. I guess first, just to comment to Representative Johnson's point about missed addresses. I'm not a landlord, but I would assume most landlords know the address of their tenants. I guess my first question is, there was some reference to other states having something on the books like this. Could you respond to that? Are we proposing something here that other states have implemented, or something that's we're the first state to do it? Or if you could just...
And to that question, Mr. McDonough, in the interim, I had occasion to be on a panel at the Mitchell Hamlin Law School at their mediation center. And on that particular day, one of the mediators said, in fact, 43 states allow more time between notice and eviction than we do. I've been meaning to check that fact, whether that was the case, but that was a surprising comment to me. I see somebody saying, yes, that is the case.
Representative Howard and Representative Hausman, yes, that is the case. So we are not creating something brand new here. This is something that most states have. And also to say again, this is the same kind of notice that the tenant would have to give if the tenant says, I need some repair problems. If I have repair problems as a tenant that are non-emergency, I have to give a 14-day notice. And the reason for that is to give the landlord time to respond to that. Now, one could say, well, the landlord ought to know that there's disrepair, so they shouldn't have to have any time. But I think that is a good thing, that the landlord has the time to figure that out, get things done, and maybe work things out with a tenant. This is simply the flip side of it, and it's something that's done in other states and successfully.
We have no further questions. Do you have concluding comments, the author?
Thank you, Madam Chair, and thank you, members, for listening to the testimony of House File 1972. I just want to highlight that we are trying, what we're trying to do here is not something new. Minnesota is one of the only 7 states that don't require a notice of eviction. Evictions are expensive both for tenants and landlords, and they hunt tenants for 7 or more years. And we are in a housing crisis. This will help, at least for some people, that they don't get evictions filed on them. I know many folks that I've worked with in the past in my housing consultant career that they didn't even know that eviction was filed on them until they get a letter from a court that's saying that you have to appear in court. So if we were to have this legislation, it would prevent that from happening. If people get a letter that says you have 14 days to pay rent or eviction will be filed, I am sure most people will react that positively and find means and ways to resolve that issue. And I thank you for taking up House File 1972. and I ask for your support.
Representative Hassan renews her motion that House File 1972 as amended be re-referred to the Judiciary Finance and Civil Law Division. All in favor say aye.
Aye.
Those opposed say no. That motion is on its, that bill is on its way.